The first case this afternoon is Thiel v. Goyings. I understand, Mr. Hudson, you are sharing your time with Ms. Cohn. Is that correct?
That's right, Your Honor.
Okay.
With the court's permission, the court has granted 5 minutes of oral argument time to the amicus party.
You bet.
And Your Honor, I would like to reserve 2 minutes for rebuttal.
Okay.
Your Honors, the question in this case is whether the Goyings built a modular home within the meaning of their neighborhood covenants. And I think the key to this case, the nub of the case, is that it's undisputed that the Goyings home is mostly not modular. 31 or 41% of the home is the modular components, which were then blended into the custom-built, custom-designed lakefront home. So the question becomes, is a home that is mostly not modular a modular home within the meaning of these covenants? And 3 definitions have sort of emerged in this case for a potential definition of modular home. Is a modular home a home that's entirely modular? Is it mostly modular? Or is a modular home any home that contains a module? Now, the circuit court held that the first definition applied and that the Goyings home was not a modular home because it was not entirely modular. That definition works. It works harmoniously across the covenants. And it would bar the sort of classic traditional modular home structure that's built entirely off-site and then plopped down on a lot somewhere. It would also sort of logically bar the sort of structure that a covenant that bars things like berm houses, mobile homes, shacks and barns would bar. So that definition works, and the Goyings home does not violate that definition. We've proposed an alternative definition that addresses some of the problems that the plaintiffs have raised about, if you slap a deck onto a modular home, is that not a modular home anymore? So we've suggested that a modular home is a home that's mostly modular, predominantly modular. That's the way we use the English language. That's how we use adjectives, modifiers like modular. A brick house is a house that's mostly brick. A log cabin is a cabin that's mostly built of logs. A glass house is mostly glass. And since it's undisputed that the Goyings home is not mostly modular, it doesn't fit that definition either. Now, the plaintiffs have not come forward with their own definition of a modular home. Maybe we'll hear one today. But at best I can tell, their position and the Court of Appeals position is that a modular home is any home that contains a modular component. And of those 3 definitions, I think that's the one that doesn't square with the English language in normal usage and doesn't work with this covenant in particular. No one would ever call a cabin with 1 log a log cabin. No one would call a house with 1 brick a brick house. No one would call a 5,000 square foot home with 1 modular bathroom component a modular home. Now, is this a closer case? Sure. The modular components here were the main living floor of the house, and the 31 or 41% number means that factually this is a closer call. But one way we deal with close factual questions is to have a trial. And we had one here. The court, after a 3-day bench trial, determined after hearing witnesses and testimony that this home was not majority modular and therefore was not a modular home.
Counsel, you
Yes,
started off with 3 definitions, and it sounds like, I'm trying to figure out what's the framework for us to make a decision about what this term means in these restrictions. And you sort of preface it as, you and the other parties are, getting together, and you got a couple ideas, they got some ideas, maybe you guys can work out between you the definition of the term. And that's not really how we think about the meaning of words in contracts or statutes.
No, you're right.
We think about whether they're legal terms of art or ordinary usage terms, such that we might look to a dictionary definition. And it appears that the Court of Appeals did some dictionary work, although I think it was a little sloppy in the work that it did, because the Court of Appeals referred us to 2 definitions. And the definitions are different senses of the word modular. But the one that I think strikes me as correct and sort of obviously correct is the one that talks about being composed of standardized units or sections for easy construction or flexible arrangement. And I think it's sort of obviously correct because the illustration is a modular home. So that seems like the sense of the word modular when used before the word home is probably that definition. Would you agree with that?
Well, the Court of Appeals quoted the definition of a module, and I certainly agree that we should be looking for the commonly used meaning of modular home. But quoting the definition of module is like quoting the definition of log and asking whether that tells us if this is a log cabin. It's sort of a difficult question. When does a log cabin become a log cabin? And just the same way, it's a difficult factual question. Where on the spectrum does a home become a modular home? When does the part become the whole? And we suggest that it's when the part predominates.
Let me just jump in. It's modular, not module, I think. Modular being the adjective that modifies home. And I think the definition maybe goes a ways towards answering your question if we focus on the definition. It says, part of it says composed of standardized units. And then the rest of it says for easy construction or flexible arrangement. I don't think the parties are contesting that the modules here would lend themselves to easy construction on the site. Correct me if I'm wrong on that point, but so I've been focusing on whether this home is composed of standardized units. Do you have a position on that, whether this home was composed of standardized units or whether these modules were more of a custom variety?
Your Honor, I do not dispute that there are 3 modular components in this home. I'm not fighting the word modular. I'm not fighting the word components. The question we're answering, though, is whether this is a modular home. And if the court accepts the premise that a 5,000 square foot home that contains a modular bathroom unit or 2 modular bathroom units is not a modular home, then I think we're in the same, we're
I'm not here
analyzing this
to
in the same
negotiate with
way.
you. You seem to think this is a negotiation. If you can get me to accept this, then I'll up the ante to that. I asked a very specific question about whether these modules were standardized. If you don't have an answer, that's fine, but if you do have an answer, I'd like to hear it now.
The modules, there is no dispute, they were built off-site, and they are used, they're used like other components that are used in a house to build. Other prefabricated components are built off-site and then incorporated into the home. And so these are just like, for example, roof trusses, modular cabinet systems. And the question is, if you use prefabricated or modular components in a home, does that transform your home into a modular home? And the argument I'm making is that not every home with a module is a modular home. But even if the court disagrees with every word I've just said, the court has asked us...
What if I said, the question is whether every home with a standardized module is a modular home?
I guess I don't see the difference between a standardized module and an unstandardized module. These were custom-built modules.
So you disagree with that?
So then you say it's not standardized.
I guess that's the answer, is that this was not a...
standardized.
These were custom-built, custom-designed, custom-built. All of the sort of configurations and furnishings within each module were custom-designed and selected. So they were non-standardized.
Okay. I'm trying to work within the definition that we have, so you can either work within that definition or reject it and point me to another one, but I don't know another way to do this work.
No, I think the commonly used definition of modular home, the way we use that term in the English language, is either it's the traditional classic modular home that's entirely built off-site and moved here. That was the circuit court's definition. That works harmoniously within the covenants. Or if it's not entirely...
It has to mean a little bit more than that, though, right? Because in these restrictions, there's one restriction that entirely would apply to relocated residences, right?
There is a... this covenant bars a prefabricated or modular home. And so that means that whatever goes for prefabricated has to go for modular. And so if a modular home is any home that contains a module, then a prefabricated home is any home that contains a prefabricated component. They reject that definition. We reject that definition. I think anybody with a grasp of the language rejects that definition because it's not how we commonly use those terms.
Your clients made a counterclaim along those lines, is that right, against one of the plaintiffs?
They did, yes.
And that claim was dismissed by the trial court?
The trial court ultimately decided that some amount of prefabricated components were permitted in this neighborhood. And so the use of one prefabricated roof truss or the plaintiff's superior wall system for their foundation or some modular components are permitted. And the only thing that is not permitted is an entirely modular or prefabricated home. That's what the circuit court concluded. We're willing to give a little more on that and say that the way we use these words is, if the modular or prefabricated components predominate, are the majority components of the house, then in the natural use of the language, we would call that a prefabricated or modular home. Your Honors, I do want to say...
I'm wondering if the better approach to this case now wouldn't be to directly get to the question of what do we do about it now? The contract for the construction talks about this as being a modular home. The builder describes itself as a modular home manufacturer. State of Michigan describes this in its state inspection as a modular home, and the building permit describes it as a modular home.
No dispute, Your Honors.
No, I didn't expect there would be disputes, but I'm just wondering, wouldn't it be more productive as a result to determine whether or not there's any exception to the injunction that seems to be pending here?
Just very quickly on those points, the builders and inspectors are using this term in a technical sense. The sense that we are focusing on is what does an ordinary, everyday homeowner understand the word modular to mean. But I will turn to the equitable.
Well, I think we know what the...
we know what the builders and inspectors consider.
I think we know what the plaintiffs, as one half of the parties, think about this too, don't we?
We certainly understand their position that this home should be torn down. But even if the court disagrees with me on the textual meaning of modular home, if ever there were a case for equity to sort of ride to the rescue, it's this case.
We've got 3 minutes and 40 seconds to go on that.
On one side of the equitable scales, the plaintiffs have suffered no harm, not a penny of damages. The property values in this neighborhood actually went up as a result of this home. It's not an eyesore. It's undisputed that nobody walking by on the street would ever know that there are modular components hidden within this home. And on the other side, we have what would be devastating harm to the Goyingses. Their house would be torn down. They would have nowhere to live. They would be financially ruined.
Do you want to let do you want to share your time at all? It's 3 minutes left.
Oh, is this 3 minutes total, or is this 3 minutes of my time? I think it was set at 10 minutes.
Oh, it was set at 10? Is that correct, Jeff?
Oh, 15.
Yeah.
Then I will yield the balance of the time to the amicus party. Thank you, Your
Okay.
Honors.
May it please the court, Brittany Cohn on behalf of the Modular Home Builders Association. I will talk fast. Modern state-of-the-art modular building is not the same as it was 5 years ago, let alone when the Timber Ridge Bay Restrictive Covenant was drafted. The drafter of that covenant testified that his intent in drafting it was to maintain a certain standard. And the purpose of that restrictive covenant and its prohibition against modular homes was to maintain the congenial occupancy of the premises and to protect the value of the homes. The drafter's outdated assumptions about modular homes, and according to the modular homes aesthetics and the prevalence and their use today, is not applicable to the custom designed modular homes that are now used in general or the Goyings home here. The Court of Appeals adopted a broad definition of modular, as you were discussing, that essentially makes any home with a modular component into a modular home. And affirming that opinion would chill the interest in system-built homes, and in doing so stifle Michigan's affordable housing industry in the face of the state's ongoing housing shortage. To put it into perspective, approximately 25% of Michigan local officials report a shortage of single and multifamily housing in their community. And however, the commercial and residential markets have embraced modular homes, system-built homes in their use. Nearly every home incorporates some type of modular piece.
Counsel, if I build a modular home, do I necessarily know it's a modular home? What I mean by that is, if I hire a contractor to build a home, and then if I follow the Court of Appeals definition, and they insert certain parts of the home to be modular, does everyone necessarily know that that's in fact what they're buying? If you hire a general contractor to build you a home, is it possible the general contractor could use parts that are modular and you wouldn't necessarily know that that's the case upon the completion of the home?
Well, that's something you'd probably have to look into with your contractor, but yeah, that is quite possible because it's used so prevalently amongst workers now as a way to keep the costs low and to increase the efficiency of the homes. And in fact, if the court were to affirm the Court of Appeals and approve of this broad definition of modular homes, no matter the quality or the aesthetic appeal of the homes or how much that home is in fact modular, if your contractor used one modular piece, then that broad definition would lead people to be reluctant to have the modular pieces.
So I would have to follow every element of what my contractor is doing if I'm building a home to make sure that it would be in conformance with such a regulation. I might just not even know. I might just say, here, I'm building a home. I don't know how the bathroom is constructed. I don't know how certain rooms are constructed or how you're going to do certain elements of it. But I could wind up with a modular home not realizing it is a modular home and not having that as my intent and then be in violation of like a covenant like this, correct?
Yes, and then your neighbors could decide, hey, I don't like your one bathroom, that's a piece of modular, and get your house torn down if this is affirmed.
Okay.
And that's the risk that we would be facing here if this was affirmed.
I appreciate you coming here and giving us a little bit of information on the technology and changes in modular homes and how things have changed perhaps since this covenant was put into place. But what are we supposed to do with the words, all residents shall be stick-built on site? And then it goes on to preclude modular homes, mobile homes, shacks, or barns.
Your Honor, I would suggest that this specific restrictive covenant is perhaps outdated and that the Goyings home was not modular as defined by this restrictive covenant.
Was it stick-built on site?
It was majority stick-built. It wasn't, the restrictive covenant wasn't specific.
All residents shall be stick-built or not, is not specific.
I would say that it was majority stick-built, and in this situation, this modular home, if you look at the negative idea of the sentence, that it was, a shack, a berm house, a geodesic dome, and a modular home, that's not what we have here today.
Okay. Thank you.
Thank you, Councilman.
Thank you.
My switch isn't working. But that's okay, because it's not bad. Good afternoon, Your Honors. Jill Wheaton for the plaintiffs' appellees, and with me at council table is my partner, Todd Shebor. There was a lot of talk today about what this case is about. We're here on an application. So in my opinion, this case, the question of today is, should you even take the case? And I don't think you should, because the Court of Appeals didn't get it wrong. Justice Markman, you kind of stole my thunder for me, because I was going to do the whole, the contract with the builder was for a modular home, the appraisal called it a modular home, everything called it a modular home.
May I ask you a question, though?
Of course.
You've got a right, of course, to pursue whatever claims you think are warranted under this restrictive covenant here. But accepting for a moment the premises that this is a nice home, it won't impair property values, it's not an eyesore, what is the reason why the neighbors in this case, your clients, want to remove this home? What is the real reason? Give me some sense of it, if you would, please.
It's to enforce the covenants, and I'm actually going to use your words to answer your question from the Tarian case. And in Tarian v. Switt, you quoted, "The plaintiff's right to maintain the restrictions is not affected by the extent or lack thereof of the damages they may suffer for the violation. It all comes down to the well-understood proposition that a breach of covenant, no matter how small, no matter how de minimis the damages, can be the subject of enforcement." That's my answer to your question. And there was no testimony at trial and no finding as to whether or not the property value of this home went up. Clearly, my clients are not thrilled with this home, or they wouldn't be here today.
Clearly, your clients what now, please?
Are concerned with the home and the...
What are they concerned about with the home if it's not going to detract from property values or create an eyesore or cost them anything? What is it they're concerned about? They do have the right.
They have the right.
To to maintain the integrity of this agreement. I
Yes.
respect that.
Yes.
But is there anything more, is there any disagreement that you have with the characterizations that this is a nice home, it fits appropriately in the neighborhood, it
No.
won't detract from anybody else's enjoyment of their property?
To me, that's very subjective, whether or not it's a nice home. I think Frank Lloyd Wright is great and a genius. My mother thinks they're modern monstrosities. So it's not for us here to say if we like it, if we're okay with it. The question is, the point is, my clients built in a neighborhood in which they understood there would not be certain types of homes, modular among them. And if you look at this home and the way it was brought in, on 3 large flatbeds that would have had the, huge load ahead signs, flags waving, and plunked straight down with everything fully in them, floors, everything. That's a different home than a stick-built home.
Is it
might
possibly
look
you're
nice.
concerned that, is it possibly the case that your concern is not specifically with this home, but it's with what I'll call the slippery slope argument?
Yes, the slippery slope is super slippery in this case. And what we're concerned about in this case is if what you can do is ignore a restrictive covenant, build a home, and then go in and say, but it's nice. Make an exception for me because it's my dream home and it's nice. You get on a huge slippery slope where courts are going to have to look at and say, well, I think it's nice. Do you think it's nice? I don't know. Maybe it's nice. You have to also look at the timing here when we talk about the equities. Am I happy to be here asking for equitable resolution? No, I'm not. Was the Court of Appeals happy? No, it's not, and it said it wasn't. Will this court be happy if it denies leave to appeal? No, but you're enforcing the law.
Is there
You're
any equitable
enforcing the
argument to be
contract.
made that you waited on your interest longer than you needed to? I mean, this
Not-
home was being built over some period of time. I
No.
mean, were your clients oblivious to the fact that
Not
this
at
was
all.
arguably in breach of the covenant?
Not at all. In fact, Your Honor, if you look at the chronology, those 3 trailers with the mobile units arrived on June 8th, 2015. This lawsuit was filed 10 days later, June 18th. The construction continued to go on through the litigation. Things hooked up, decks added, all this stuff added, all went on while this lawsuit was pending. So I analogized this case to the Webb case. In the Webb case, the question was reciprocal negative easements being violated? Not something very clear, like the defendants knew about here. They don't ever claim they didn't know about this. In fact, there apparently was testimony at trial about discussions with the builder about whether this was indeed permitted under the restrictions. So to answer your question, Justice Bernstein, if your builder, if you don't realize what the builder's doing and you have made the builder aware of your restrictions and the builder doesn't follow them, then frankly your action is a lawsuit against the builder. It isn't to get an exception from a restrictive covenant to which you agreed. And in the
Counsel, can you
Webb
help
case,
me-
the court
Counsel,
said,
Can you help me understand what the correct definition of the term modular is for
Well-
purposes of these restrictions?
I like the Court of Appeals definition, the one from
Well,
Random House.
Which one? They gave you kind of a menu of options. So
Well, I mean, I'm
point me
looking
to
right
one.
at it, page 6. I only see them citing the Random House, and they have, number 1
See where it
under
says
Random
number
House
1
2.
and number
Yeah.
2?
Number 2.
Oh, you opt for number 2?
Right, because number 2 used as an example,
Okay,
a
so we're on the
modular home.
same page there. So
Right.
can you tell me, I'm just trying to ask the same questions I asked of your opposing counsel, whether this home was composed of standardized units or whether the modular units in this home were of the custom variety? Because it does appear to me that in this industry that it's allowed in recent years for a lot more customization. So-
Right. If you look at the website for the builder in this case, which is Ritzcraft, they describe themselves as the largest, quote, modular home, unquote, manufacturer.
But Justice
And-
Viviano was
but-
just asking a different question. Can
No,
you
I
just
know,
answer
but I was
that
going to
question?
say, if you look at their website, you choose from a menu of options. It's almost like looking at Legos. Do I want a module that's this big and rectangular, or this big and square, or this big and and
So
Is
not
that another way,
standardized then?
is that another
So-
way of saying that the modules are not, standardized?
No, I think they are
You're too
they're
fast.
standardized. You have to choose between, say, 5 options. And then inside you can say, I want this kind of cabinet or that kind of cabinet. But the bottom line is, it is not a stick-built home, as Justice Zara pointed out, and you're choosing from prefabricated, pre-designed options.
How should I think about standardized versus non-standardized modules? Help me to think about that, the distinction. Because the implication there is that some some modular, or some homes composed of modules or other things might not be standardized, right? Or that's not how we should think of them, as modular homes if they're not standardized, based on the definition that you agree is the one that applies.
I view it as more of the stick-built versus built in a factory distinction. And so standardized to me means this is coming out of a factory. These units are being pre-made.
But if you
Everything
say, oh,
Go ahead, no, go ahead.
You
Go,
you
keep
go.
going, no, you're on a roll, go.
If you say a stick-built home,
No.
are you saying the entire home is built from raw materials on the site?
No, I'm
Cut
not
down
saying
the
that.
tree and plane the wood?
Right. No, I'm not saying that. But I'm saying it is built on site versus built somewhere else. I think the problem with a modular home is the same, or at least the perceived problem, whether or not, but the perceived problem was that, like a mobile home, is something that is made somewhere else, prefabricated, brought to the site. And that's what happens here. These modules are built in factories. Here's, 400 of this size and 400 of that size, 400 of this size. And the Goyings want 1A, 1B, 1C. Off they go in the trucks to them, and it gets plunked down. Now, whether you call it standardized because they chose A, B, and C versus 2A and 1B, I think once you start looking at that, then you're reading the guts out of this provision, which is essentially
I'm
no
not trying to do that.
prefabricated
I'm
home.
trying to read the guts of the provision.
Right.
And it says standardized modules. So would you agree with me that you can build a modular home that's not standardized? Is that possible, or is that not possible? In your
I do not know enough about the modular unit. I don't think so. I think.
Are you
to me-
urging us to accept the definition that any home with modules is a modular home?
No, I'm saying that one that is built, composed of standardized units, and it's hard to explain. It's when the meat of the house, I mean, these three things were plunked down on the footprint of the house. All that was added was deck, garage, porch, that sort of thing.
But isn't
So
that
the
a
home
slippery
itself.
slope? Isn't that the slippery slope the other way, though?
No.
In terms of what you're arguing? I mean, basically, you're saying it's a slippery slope if you allow, this specific home as it pertains to this. But isn't it a slippery slope? Couldn't you go the other way, where if you have a specific room as a modular room, if you have a specific section as a modular section? I mean, couldn't we be concerned that your definition takes us too far the other way, which is that
No.
any portion that is seen to be modular could then induce the covenant, could then require the house to be torn down?
No, because the restriction says modular home. It doesn't say home with modular unit, that sort of thing. And if you want to get around this rule that the defendants are proposing, is you could take a geodesic dome, a prefabricated house, or a modular home, look at the square footage and say, I'm going to build a deck and a garage and a this and a basement that comes to just over that amount. And then I'll say, my home is no longer majority modular. Well, it still is. The base of the home still is.
So your
And
definition is if the base is modular, it's modular? But as between the definitions Mr. Hudson
Right.
articulated, which one do you like?
Again, I like the definition one, composed of standardized units, but maybe it's, base, essentially. The home is composed of, not the entire property when additional material is added to it.
No, I'm not asking what the definition is not. What's the definition you like? Mr. Hudson articulated a number of them. You might like a different one. I'm just asking, what is the definition you like?
Well, he had a couple. First, he said it has to be that we're saying 100% modular, and then he said 51%. I honestly don't know where he was going at.
I heard him
know.
already. You don't have to repeat what he said. I just
I'm
want
trying
to
to
know what
remember.
you think the definition is.
You asked which one I
What
picked.
do you want the definition to be in an opinion?
I don't want you to have an opinion in this case, to be honest.
Well, let's say we get there.
I don't want you to have an opinion.
Okay, you got 3 minutes and 44 seconds. If you don't want to talk about that, let's talk about if there is a violation,
Yes.
perhaps the remedy should be something less than tearing it down.
Honestly, to be fair, I was going to that
Interesting
before.
words, to be fair.
What?
Interesting words to start whether we should tear it down with the
I know,
words, to be fair.
and it is something you hold your nose at. And we're talking about the timing with Justice Markman, and he talked, and I was starting to talk about the Webb case, and then we went down another path. In that case, the court noted that the defendants continued to build their home during the course of the litigation, and said, by doing so, This case demonstrates the folly of gambling on the prospect that the judicial system will ignore and not enforce property rights, and the gamble may result in the unfortunate outcome that you must tear down a home that was built.
Okay.
And unfortunately, that's what needs to happen here, because otherwise you will have people coming in after the fact, going into court and saying, oh, to enforce this will be a hardship.
Ms. Whedon, can I ask you a couple questions? You said the defendant's brief says that you argued below that the home also violated the covenant, providing that homes must be, quote, stick-built on site, but you abandoned that argument on appeal. Is that correct?
Said we didn't argue it too much because at the trial court level, the judge, I believe, just didn't get to that. Is that right, Todd? Yeah, the entire decision at the trial court was based solely upon
So that's
the
not a
modular.
subject of that's not a question you think is before us, whether that particular part of the covenant is violated.
Well,
is that
I
correct?
think it could be an alternative grounds for affirmance that the Court of Appeals got it correct, even if you think they misread one definition, that still.
Even though you haven't asked us to find that.
Right.
Okay, and your definition of modular is not 100%, but it's based on the foundation, is that correct?
Essentially, yes. In this case, it was, the foundation, the total square footage without attachments.
Do you agree with the defendants that there are the trial court's factual findings, there's nothing erroneous about the trial court's factual findings? You haven't argued that there's anything erroneous about the trial court's factual findings, is that correct?
Well, we did below in the Court of Appeals, but then we won in the Court of Appeals, so to you, we're trying to affirm the Court of Appeals ruling. What the trial court found, and which we frankly don't really disagree with, is that this home is modular, and it is modular, there's a large percentage of it's modular, but not 100%.
So the problem is, like, there's factual findings and then there's a legal term of art, and we're talking about a legal term of art, and how we define it is not something I've been able to get a clear answer from you about. But I'm asking now about the factual findings the trial court make, like what percentage of this particular home was from modules. Do you object to any of the factual findings the trial court made?
I don't believe so.
Okay.
I would need to go back and take a quick look, but.
So then it would have to be that your definition is, even though it's less than 50% modular, it's still modular because of this foundational kind of
Yes,
vibe?
right, because what the trial court said was that the term systems built modular means nothing. She believes the home was modular, but declines to find that it was in violation of the covenant because it was not, quote, entirely modular, because a deck, a garage, and a porch were added to it. And what I'm saying is that is a erroneous interpretation of the term as defined, because the basic home, maybe this is the ad that we talk about, the basic home that went, inch for inch upon basically the foundation is modular, and the fact that things were attached to it should not take it out of the exception.
And the fact that modular in 2015 is actually superior quality than many stick-built homes should be something people can work out in renegotiating their covenants.
So says the Modular Home Association, which is a little ironic that they're here in support of an argument that something is not modular, but I'll end with that. If that can be renegotiated.
I do think they probably should have changed their marketing a long time ago.
Yeah.
Thank you very much.
Counsel, actually,
you have a question?
Yeah, if I could.
Okay.
I just want to emphasize one key emphasis here is that you acknowledge that this is quite draconian, that you're going to put these people into financial ruin and completely make them tear down their entire home. I know we've covered it, but you recognize the draconian nature of what it is that if this court doesn't act, these people will lose their home, correct?
If they abide by a court rule, yes.
And I guess the question is there any other scenario that you could think of if you're looking at a covenant that would require a remedy this extreme? Like, what else would there be anything else that if we were to hold? I guess the question is, you don't see this as just a technical violation. I mean,
heck no.
Are there other scenarios that you could give me another scenario that would require a draconian response like this?
Well,
what else could I do in this neighborhood that would require this kind of remedy to tear down my home?
You could put up a geodesic dome. You could put up a prefabricated home. And this court and other courts below have done this before. This is not unprecedented. There have been cases before where homes were constructed in violation of restrictive covenants and the homes were required to be taken down. Buildings, commercial buildings in the one of the cases, the one that set up the Cooper case, the one that set up that equitable exception, had a commercial property that was built. That was ordered to be taken down.
And I hear what you're saying, and my last question would be, though, is that my understanding is that the neighborhood association is concerned about, I guess, the aesthetic look within the community, correct? That's the idea that you...
Mm-hmm.
Is that the overriding... and Justice Markman asked this, but I'm still kind of trying to understand very quickly. We don't have any time left, but your biggest concern is what? You feel these homes are destructive? I just trying to understand, you feel that they destroy the neighborhood? Is that the idea?
Well, I'm a little put on the defensive by asking why we want to enforce a restriction. We want to enforce a restriction because my clients paid for property in a neighborhood that had certain restrictions. Right. And so to then be asked, well, why do you want to enforce those is a little, because we have the right to. And it does start you down that slippery slope of, well, if their house is okay, then a house with a little bit more might be okay, and maybe this might be okay. And frankly, if this was their dream home, they could have built it on a score of lots. But they chose one that had a restriction. And in choosing one that had a restriction, they agreed to abide by that restriction. And if this court is going to allow people... My last question. And that restriction is so important that they would rather live next to a torn down... I mean, this could go on for years. They would rather just live next to a lot that is just torn down. That would be a better... They would feel that is a better remedy than living next to this home. They'd rather have a lot where you basically have a home that's been torn down, and they would rather have that because that's more desirable than the house that's there. Well, I'm going to cite a case from this court from almost 100 years ago, Austin v. Van Horn. Restrictive covenants are to be enforced regardless of the effect or lack thereof on the other homemakers.
Thank you,
homeowners.
counsel.
Thank you, counsel. The case will be submitted.
Thanks.